Okay, so we're going to pick up where we left off. We've done pages 1 through 5. We're going to pick up on page 6, and a lot of material here. So page 6 has to do with time periods, removal of contingencies, and cancellation rights. There's bold print that the time period set forth in this agreement may only be modified by mutual agreement, and removal of all contingencies or cancellation under this paragraph by either buyer or seller must be made in good faith and in writing. So basically, it's putting everybody on notice that these time periods can't change without written agreement between both parties. It goes on to say that the seller has 7 days or as agreed to provide the necessary documentation that they're required to provide. If by the time specified they're not delivered, the buyer may issue a notice to perform, and if not acted upon, they can cancel the agreement. Continued on this is the buyer has 17 days after acceptance of the deal or as agreed. You can change those time periods, but 17 is the default to complete all investigations, review the disclosures that the seller gave to you and other applicable information received from the seller, and approve all matters affecting the property and deliver the seller all signed disclosures delivered by the seller. So they have the 17-day period to do that. Within the 17 days, the buyer has the right to request repairs or some other action, and the seller but the seller is not under any obligation to even respond to those buyer's requests. Now, we know that it's customary. I mean, it leaves loose ends if the seller doesn't respond. So it is always important for us to be able to communicate. And if the response is we're not going to do anything, then we're not going to do anything. We had a transaction this week where the buyer came in and asked for $150,000 in repairs, probably one of the bigger ones that we've had recently. The seller came back and offered him $7,500 in repairs, and we went back and forth, and basically they ended up not giving any repairs because the buyer figured out that at the end of the day, they wanted the property regardless. So, but the seller is not under any obligation to even respond. You'll end up running into situations where you'll be caught in a situation where the other side is unwilling to give you a response to your request for repairs, and it feels wrong when they do that. But that is their right, and that is what the contract says, that they are not required to even respond.
Steve?
Yes.
Is that because in California we keep hearing real estate is sold as is?
Well, the contract says that the property is sold as is, subject to inspection rights. It's not necessarily California law, but that's the way that the California Association of Realtors has written the purchase agreement.
Okay.
So yes, that is the reason why the property is sold as is, subject to inspection rights of the buyer, and the buyer also has the right to ask for some action, either repairs or money or something. But even though they're allowed to ask for it, the seller is under no obligation to give it or even to respond to it, is what the contract says.
Okay.
Within the 17 days, the buyer shall either remove the contingency or cancel the agreement. Items not delivered by the seller timely, okay, the buyer has 5 days or the original agreed upon time period to review and either approve or disapprove the information. We had a situation today where the buyer removed all contingencies, and the listing agent forgot to give one of the disclosures, okay? And they were providing the disclosure after the fact, after the contingencies were removed. And the question was, what does that mean? Does that mean that a new contingency period has started? And the answer to that question is yes. And so that person is given, the buyer is then given 5 days extension on their contingency period, and they must, again, actively remove those contingencies. It gets a little bit complicated, but just remember, if you're providing something after the fact, okay, that you forgot or there was a mistake, then you are potentially creating an additional time period. The worst case scenario would be you give them the document after the fact, they have 5 additional days, and that contingency is still in place, and you don't do anything about it. You don't ask the buyer to remove the contingency, and you go to day 30 and you're ready to close, and the buyer says, well, I never removed that contingency for that document. Well, yes, you did. You already removed all contingencies. Well, but you introduced new information after the fact. Okay, so be careful when you're giving additional disclosure after the fact. Be careful, because if it creates that additional contingency, that could be an out for the buyer, and your seller's not going to be happy at all. Even after the time period of the contingency is if it's not removed in writing, it continues on giving the buyers the right to cancel. Sellers misunderstand the 17-day period as that's basically after the 17-day period, they're home free. They're not home free until the buyer removes those contingencies. The contract provides for active removal. The 17-day period is just a benchmark. So be careful with that, and make sure that when you're talking with your seller regarding the contingency periods, that they understand that those run until they are removed. Okay, buyers shall have access to the property for inspections for 17 days or as agreed, regardless of any contingencies have been removed. So that 17-day period. Now, what happens if you get to day 19 and the home inspection wasn't done? Well, technically, the buyer doesn't have the right to do those inspections. Okay, but the seller's not going to prevent them from doing it. But it does create a level of urgency to make sure that you are moving forward and you're doing things within those specified timelines. There's a checkbox offering for removal of contingencies with the offer. Buyers acting, it goes on to say that the buyer is acting against the advice of the broker in bold print if they remove the contingencies with the offer. Removing contingencies with the offer could be a tactic that someone might use in order to make their offer seem more attractive or stronger. You know, they feel comfortable with that. Would highly recommend that you be very careful with that and not advise your clients that that would be a good strategy for them to undertake, because it does also say in the document that they're acting against our advice. We're going to tell them that they should not do that.
Hey, Steve.
Yes.
I just ran into a situation during this inspection period. We were down to 12 days because that was part of our RPA.
Right.
But the home was a part-time renter. And so it was really hard to get access because she had the owner had it rented out like 80% of the time.
Right.
For future use, I mean, is there something I could have done there if they would have forced me after the 12 days?
Well, they're in breach of contract. I mean, I don't know who's we've got here. Hang on one second. Let me just see who we've got going on here with the.
Oh, yeah.
Okay. Sorry, hang on one sec. They're under breach of contract for not providing the property to you. They have to provide access to the property. We talked about that last week in the other part of the contract.
Or if you want an agent.
Hang on one sec. I got some. I'm going to mute everybody. Just unmute yourself if you have to speak. Okay. All right. So, as I was saying, they're in breach of contract. So that could be a circumstance where you would offer the other side a notice to perform for them to grant access, to allow for you to have access to the property. It's kind of a specialized situation, Ruben, because, these people that have these short-term rentals, I know that there's a couple other agents that have properties that can only be shown during certain time periods. Once you're in a contract, if you're dealing with a seller that is not making the property available or accessible for the buyer to do their inspections, that's when you've got to issue a notice to perform for them to comply with the contract. And if necessary, ask for an extension for additional time because they're not making it available for you.
Okay.
Does that answer your question?
Yes, it does.
Okay. If buyer fails to remove the contingency, seller may issue a notice to perform, then cancel. This cancellation returns the deposit to the buyer. So That the remedy when you issue a notice to perform, we all know that, is that the seller has the right to cancel on the buyer, and if they do so, then they have to return the deposit. Seller's right to cancel buyer contract obligations. So the buyer's notice to perform is required. Then the seller may cancel for the buyer not depositing the EMD, or if they find out from escrow that the funds aren't good, if the buyer doesn't deliver the FHA or VA cost verification. These are all items that are listed under contract obligations. So if they don't do that, if they don't provide those things, the seller just doesn't have the right to cancel. They have to issue the notice to perform and then again return the buyer's deposit. If the seller cancels the buyer, I just said that, the buyer's deposit is returned. Notice to buyer or seller to perform must be in writing and signed by the applicable buyer or seller. We have a form that does that. It must give the other party at least 2 days to take the necessary or specified action, and it may not be delivered more than 2 days prior to the expiration of that contingency period. So whatever it is that the seller is asking the buyer to perform on, they need to give them the 2-day period, which is built into the document. They can give them more time, but 2 days is the minimum. And for example, if contingencies are to be removed 2 days from now, okay, that's the due date, you can issue the notice to perform 2 days in advance, so that if they don't remove them on that time period, then the seller has the right to cancel the transaction. It can't be issued prior to that. It can only be issued the 2 days prior to it. If they wait until the expiration of the contingency period, then issue the 2-day notice, the notice to perform, then they've got another 2 days that they have to wait. So to be proactive with it, you want to make sure that you know what dates you're dealing with and then issue the notice to perform 2 days prior to that. Effective buyer's removal of contingencies. If they have removed them, they have deemed to completed the investigations and review the reports and other applicable information. They basically said, hey, I'm electing to move forward, and assumed all liability for any repairs or inability to obtain financing. So if, for example, they have removed the contingencies, then at that point, unless there's new information that gets introduced into the transaction, they're basically saying, hey, we're going to take this on, and we are moving forward.
Steve, I have a question.
Sure.
Just as you say, if they're unable to obtain financing at the rates that they were expecting, what about if they're having a problem with fire insurance?
Fire insurance is not a contingency of the transaction, so that's not necessarily built in.
No, but if they were to find it was unable to, or financially, more than they could handle for them to do a fire insurance, would that give them in their 17-day period of time say, this is something I can't deal with?
Anything within the 17-day period as part of their inspection. So they have an inspection period where they are evaluating all aspects of the property, suitability, condition of property. If they, for example, in their investigations find out that there's something financially beyond their means, sure, they have the right to cancel the transaction. If they've removed their inspection contingencies, okay, and they then find out that their homeowner's insurance is going to be, $1,200 a month, the only way that they would get out under that circumstance would be if, for example, the lender were to say at that point that because of the additional payment, they wouldn't qualify, and that would allow them to have the out. Otherwise, they're required, and this is a good point for you representing buyers, they're required to understand before that 17-day period is up what they're getting into. And part of that is, what is the cost of insurance?
So in other words, if my buyer was to contact their insurance agent during their 17-day buyer period and they found out that it was financially prohibitive for them, then that would be something they could use for cancellation?
Absolutely. After the fact, no. Okay. They wouldn't
but
be
before
able
17
to say,
days.
well, oh, gee, the insurance is too expensive, so therefore I'm going to cancel. They would not be able to do that after they've removed contingencies.
Thank you, Steve. I appreciate it.
You're welcome. Okay, close of escrow is a little bit different with time frame. So before the buyer or seller may cancel for failure to close, they must issue a demand to close escrow. Some people issue a notice to perform to close escrow. The contract specifically states that you use a demand to close escrow, and that is required. We've had people issue notices to perform to close the escrow, and they have found that they then have to issue a second, and that doesn't make the seller happy because they feel that they have already issued the notice to perform. So be careful with that. Demand, if it's a failure to close escrow, demand to close escrow is necessary. And the demand to close escrow gives 3 days. Okay, so it gives, instead of the normal 2 days for a notice to perform, the demand to close escrow is a 3-day period. So just be careful with that. Effects of cancellation on deposits. If written notice is given to cancel pursuant to the contract, the buyer and seller agree to sign cancellation instructions and release the deposit to the person entitled to funds. So it plainly says in the agreement that if they decide to cancel, they both will agree. So they're in breach of contract if they don't agree to sign the contract, or to sign the cancellation and return the monies to the person that they belong. We're going through one right now where we've got a buyer who's entitled to receive their funds back, but because the seller's upset with them, they're not signing those escrow, they're not signing the cancellation, and they're also not signing to release those funds to the buyer. And the contract, they're agreeing in this contract that they will do that. The release of funds requires mutual agreement, judicial decision, or arbitration award. So what that means is, again, just because the buyer's entitled to deposit or the seller's entitled to deposit doesn't mean they're going to get it. Okay, there has to be, escrow's not going to release it unless there is a signed agreement between the parties for those funds to be released to that party. Or in this case, what I'm advising this client to do, because the seller is unwilling to act, is for them to file small claims action, because it's only a $3,000 deposit. So they can file in small claims, show the contract, the judge will take a look at the contract, and then the judge will order escrow to release the funds to the buyer. Okay, so it's extra steps that you have to go through in order to do this, but there's a process, and it's built into the contract that allows you to do it. If either party fails to sign, the other can make a written demand to escrow using the BDRD form or the SDR form. Escrow will promptly notify the other party. After 10 days, if no objection, the deposit shall be dispersed to the party making the demand. Now, that sounds confusing. That sounds like that's a way that you can get your deposit without getting the mutual agreement. Well, it is. There is that provision in the contract, but I'm not aware of any escrow company on the planet that's going to do that, because there's further in the document, it says escrow may require mutual consent, and they usually do. They will in every instance, because they don't want to create the liability for themselves for releasing the deposit because the other side didn't say they didn't get proper notice or whatever. So just be prepared for the fact that if you have a situation like that where you're not getting the seller or the buyer is not acting accordingly, I need to know about it. I need to know about it early, because when we jump on these things early, then we have a better opportunity, a better chance for resolving them.
I have another question, Steve.
Okay.
If the seller refuses to do the cancellation, should it come down that road, does that not make the property unable to be remarketed or resold to someone because it's got an attachment to it?
Well, yes and no. There's an open contract that hasn't been canceled. Normally what happens is you'll have a transaction canceled. So the contract, the top half of the document, you have a cancellation of the escrow, of the contract, and then the bottom is the disposition of the deposit and the cancellation of the escrow. And what typically happens is the deal gets canceled, but the money gets held. And there's still an open escrow because the money is still there. And the question is, can a seller go sell their property to someone else with an open escrow? And the answer to that question is they can't do it with the same escrow company, but if they go to a different escrow company, they can absolutely sell the property with the money still sitting in escrow. We've had transactions where monies have sat in escrow and the buyer and seller can't come to agreement and they can't settle, and that money eventually escheats to the state. So years where you've had open escrows where the property clearly sold to someone else. Now, a buyer that feels that they have a claim and they're right about it can file lis pendens against the property, which would be a cloud on title action, and that would prevent the property from selling. But just simply having an open escrow with an escrow company is not enough to prevent the property from selling.
Thank you, Steve.
The last part of this is that there's a penalty that's imposed for someone who doesn't execute cancellation or if there's does not have a good faith dispute over the deposit. So my example of the guy with $3,000, he clearly is not entitled to deposit, the seller. He's just mad at the buyer. So he's withholding the buyer's funds. When the buyer goes to small claims, they will sue for the deposit, which is $3,000, and then they will sue for this $1,000 penalty. That's the maximum that's allowed. And they'll be granted it. The judge will give it to them. I've seen it happen multiple times. And it's unfortunate it isn't a bigger number. Okay, there should be a bigger number, because the $1,000 in most cases is not enough to keep that principle-centered person, which is what that usually is. Somebody who believes that, it's the principle of the thing. So they're going to, they're going to make the buyer pay, or they're going to make the seller pay, depending on the circumstances. $1,000 typically is not enough. I wish that was a much bigger number, because it would probably be a more effective deterrent. That's what it's in there for. It's basically giving a penalty for someone who's acting in bad faith, which a person that's withholding the deposit is clearly acting in bad faith.
Steve, if someone signs that, are you there? Hello?
Uh-huh.
Yeah. Oh, I'm there. If someone signs the mediation arbitration, paragraphs, can they still go to small claims court with?
Yes, they can. There's an exemption, and I'm going to get into that a little bit later. But it talks about what Paul's talking about is the requirement for you to mediate. If you agree to mediate, you agree to arbitrate. It's voluntary to agree to arbitrate rather than have a court action. There's a requirement to mediate prior to. And for items that are probate related, items that are small claims related, if it's a judicial foreclosure, a trustee sale, those items are not required to be mediated or arbitration, even if you agree to arbitration. So if you agree to arbitration, you can still use small claims if that applies. In other words, if your case would be settled appropriately through a small claims action, that is an exemption that's built into the contract. I'll talk about that in a little bit. Buyer has 5 days in advance. Let's see here. Buyer has right 5 days in advance, or has agreed to make a final verification. Oh, so the buyer has a right 5 days in advance, or some other time period, to make a final verification, not as a contingency of the sale, but to confirm that the property has been maintained, repairs are complete, and the seller has complied with other obligations. So it's basically that portion of the contract is stating that they have the ability 5 days in advance to do a verification of property. Repairs shall be completed prior to the final verification unless otherwise agreed. Repairs performed by seller may be done by the seller or others, provided that the work complies with applicable law, including permits and inspection and approval requirements. Work must be done in a good, skillful manner with comparable quality and materials. It is understood exact match of repairs may not be possible. This is kind of a sketchy one, right? I mean, sometimes we have handymen do work on these properties, and are they acting within compliance of the law? Maybe not. I mean, that's something that you have to be very careful when you're dealing with these repairs, whether or not the service providers, I mean, there's certain repairs that require permits. There would be certain repairs that would require a licensed contractor do them. Just be mindful of the fact that there's language in the contract talking about those repairs and how they should be completed. Regarding repairs also, seller shall obtain invoices and paid receipts for work done by others. Prepare a written statement of repairs done by the seller and on what date, and provide copies of the invoices and paid receipts and statements to the buyer prior to final verification of condition. This is in the contract, guys. It basically says that the seller is obligated to provide all of this information to the buyer. And we don't always do that. But if the buyer requests it, it is part of the contract and the seller is on the hook to provide that. Any reaction to that? Okay. Prorations and property taxes and other items, paragraph 17. Unless otherwise agreed, to the following will be paid current and prorated between buyer and seller at close of escrow: the taxes and assessments, interest, rents, HOA fees, premiums on insurance assumed by the buyer, payments on bonds and assessments assumed. So there's a proration clause built into the contract. There's also a statement in there that the property will be reassessed after transfer. County has the right to reassess the property at any time, but we're putting them on notice that the assessment of $200,000 on the property that they're paying $800,000 for may not be the same assessment after the close of escrow. There's an explanation of how supplemental taxes are to be paid. And then paragraph 18 talks about brokers. Buyers and seller agree to pay the broker subject to a separate agreement at the close of escrow. It talks about our scope of duty. Broker does not decide what the buyer should pay or the seller should sell for. We do not guarantee the condition of the property. We do not guarantee the performance or completeness of inspections or other work completed by the seller. We as brokers also do not have an obligation to conduct, we do not have an obligation to conduct inspections of common areas or offsite areas. We shall not be responsible to identify defects on the property in common areas, offsite, unless defects are visually observable by an inspection of reasonably accessible areas of the property or known to the broker. We shall not be responsible for inspecting public records or permits. So that's right in the contract. When the seller says, I want you to go do that, you basically have to tell them that that's not the broker's responsibility to do that. Shall not be responsible for identifying boundary lines, big one. Not responsible to verify square footage or other representations of others or information in investigation reports, flyers, or other promotional material. Again, people pick up a flyer. I hear it many times. The MLS said this, or the MLS flyer, the MLS printout said this, or the description on the property on Zillow said this. Okay, the bottom line is that they can't rely on that. Okay, if it's not in the agreement, okay, that's not our job to verify those things. Now, if it's something blatant and you know about it and you know it's incorrect, then that's something different. But if it's something that's contained in the marketing materials that is a response, like let's say that the listing agent puts something in the flyer that's incorrect, it's not on you as the buyer's agent to verify that information and make sure that it isn't correct. Broker shall not be responsible for determining fair market value of the property or personal property. We also shall not be responsible to provide tax or legal advice. We shall not be held responsible to provide other advice which exceeds the knowledge, education, and experience required to perform real estate licensed activity. I find myself saying this a lot. I said it today in an email to a client where I was giving them common practice on how we deal with this retrieving of the deposit. And I preface everything that I said that with, look, I can't give you legal advice. This person's a paralegal. And I'm telling them, okay, this is not legal advice. This is just commonly how these things are resolved and how these things are handled. And we need to remind these folks, but it's already in the agreement. It's already in the contract as well. We're continuing on with brokers. Buyer and seller agree to seek advice from the appropriate qualified professional. So we're on page 7, paragraph 19. Representative capacity used when one or more of the parties is not signing as an individual, but on behalf of an entity. They check the box above the signature line in the contract, and then it gets pulled into your contract. And I'm going to go through the ancillary documents in a future meeting, but the representative capacity basically just states what the entity is, if it's the owner or the buyer, and then it's certifying that person is certifying, and they're agreeing that they're going to provide proof to you and to escrow that they have the authority to sign for that entity. So you have the name of the entity, you have the name of the person, okay, and their title, and then it basically authorizes the fact that they're going to prove that they have the right to sign for this LLC or this trust or whatever the entity is, if it's a corporation, whatever it is. The RCSD document becomes part of the agreement, identifying the entity and the person with the authority. That's a document I just described. The person acting as a representative capacity agrees that they will within 3 days provide evidence of the authority to act. So that's, again, what I stated the document was doing, or the intent of the document. Okay, let's talk about escrow instructions, still on page 7. The contract becomes the escrow instructions. So your contract is actually the escrow instructions. Escrow issues what's called supplemental instructions, which the buyer and seller agree that they will sign and return within 3 days. So the contract says to the buyer and seller, they're agreeing that within 3 days, or as agreed, that they will sign the supplemental escrow instructions that are provided by escrow, and they will pay the escrow holder or the HOA management company, if there is one, the fees needed for the completion of the HOA paperwork. So that is something that comes up frequently, where the seller is hit with a situation where they have to write a check for the HOA fees because those have to be paid up front. And they say, well, where is that? Where does it say that? And where it says it is in paragraph 20 in the contract. Buyer and seller agree that within 3 days of acceptance, the contract will be delivered to escrow unless otherwise agreed. And then escrow is authorized to accept copies as originals. Escrow holder is authorized to provide the statement of information of the title once it's received. And escrow is also instructed on how to handle FERPTA. That is the end of page 7. Okay, page 8, escrow continued. Brokers are party to the escrow only for compensation, and the principals irrevocably assign compensation and instruct escrow to disperse at the close of escrow the compensation. So this protects us. And it goes on to say that changes can only be done by mutual agreement of the brokers. Buyer and seller hold escrow harmless for the payment to the brokers. So we've had situations where the buyer and seller, the buyer or the seller, typically the seller gets upset with the broker involved, and they say, we're not going to pay them. Well, they can't really do that because they agreed in the contract to irrevocably and instruct escrow to assign that compensation as agreed when they sign that compensation agreement. And the only thing that can change that would be agreement of the brokers. So we are protected by this paragraph. Authorization for escrow to notify seller and seller's broker if the EMD is in. Instructions to escrow to notify the broker if the funds are not good. So basically giving authority to escrow in the contract to notify if the money's in, or if it bounces, or if there's some problem with it. Goes on to say that copies of all amendments for which the escrow is required to act must be delivered to escrow within 3 days of mutual execution. So it's, again, putting a timeline on the parties to make sure that they are submitting the documents timely. Okay, page 8, paragraph 21, remedies for buyer's breach of contract. Any clause making deposits non-refundable is invalid. I had this come up today. I had somebody ask me the question where buyer and seller want to agree that they want to make the deposit non-refundable. In fact, if you release the funds to a seller early, the seller needs to know that the state of California does not allow that. In other words, that if it gets challenged, if the buyer comes back after the fact and said, you made me release my deposit prematurely and you weren't entitled to it, they can get it back. So it doesn't mean that the buyer and seller can't agree to make the funds non-refundable. Doesn't mean that they can't release the funds to them. It just means that if the buyer changes his mind, he goes to a cocktail party, okay, and he's talking to his attorney buddy, and he says, hey, I really got screwed over this deal. They made me release my deposit non-refundable, and I lost it. And he'll turn around and say, well, you should challenge that because that's not allowed. I mean, that's not something you can do. And if they decide to challenge it, then the seller could be exposed to have to refund those monies back to the buyer. Okay, it's just like the TDS. We talked about the TDS. You can't arbitrarily just decide. Both parties can't get together and say, well, we don't care, we're not going to do the TDS. It's required by the law. Okay, the law does not allow that to happen. Liquidated damages. Okay, and this is misunderstood by many people, but the advantage to everybody is that there could be, by breach of contract, by someone not performing under the contract, there could be unlimited damages. Okay, there could be huge amounts of money that could be owed, or there could be a huge challenge. All liquidated damages does is it says, look, here's the limit on it. Liquidated damages, think about that. It tells you that there's only so much that an injured party can try and go after. So it says if the buyer defaults, the seller is allowed to retain the actual deposit actually paid up to a maximum of 3% of the sales price. That's why we use 3% per deposit. It's the maximum amount that the seller can claim. Excess shall be returned to the buyer. So if there's a bigger than 3% deposit and the buyer defaults, the seller gets 3% and then the balance gets returned to the buyer. Mutual consent is required for the disbursement. We talked about that before. No money can be released from escrow without mutual consent. There must be a separate liquidated damages if the deposit is subject, an additional deposit is subject to liquidated damages. And what that means is that you have $1,000 deposit with the contract. And there, for some reason, is an additional, after 10 days, the buyer is going to deposit another $5,000. So the total deposit is $6,000. If there isn't a separate RID document or a liquidated damages, the document that adds that additional deposit to liquidated damages, then it's not subject to it. Okay, so you've got $6,000 in, buyer defaults, seller asks for the $6,000. What do they get? They get $1,000 because you did not complete the RID document adding the $5,000 to the liquidated damages. So kind of a tricky thing. If there's an additional deposit, just be careful with that and know that there's some additional paperwork that needs to be completed. It doesn't happen very often, but it is something that has come up in the past. Okay, and then you need agreement on the contract is required for initials. So that's for liquidated damages. In liquidated damages, both parties need to agree. And if both parties don't agree to liquidated damages, it requires a counteroffer. So let's say the buyer does not sign liquidated damages. The seller can't just sign liquidated damages. He needs to add it to the counteroffer. It needs to be agreed to by the parties. Okay, still on page 8, paragraph 22. Dispute resolution. Parties agree to mediate prior to taking court action. This is what Paula was talking about. So the parties are agreeing in the contract that they will mediate prior to taking court action. Brokers are also included. So if they have a dispute with us, they must mediate with us, but we're not required to. Okay, there could be certain instances where someone would want to mediate with us and we would say, no, we're not going to mediate. And that's happened. There are certain circumstances that could apply to that, but buyers and sellers are required to mediate. Okay, and the way it works is mediation fees are paid. They're agreed upon and they're paid to be split by the parties. They are agreed to be split by the parties. And if you don't agree, so let's say one person wants to mediate, the other person doesn't, all it means is that the party that did not mediate is not entitled to recover attorney's fees if they go to arbitration or it becomes a court action. So I'll tell you that 99.9% of our disputes that go past us just resolving them informally, 99.9% of them, there is a mediation that goes in, that happens first. And I will tell you that probably 25% of the time we actually settle at mediation. So they come together. The job of the mediator is to beat up both sides as much as possible, and help each realize that their case isn't quite as strong as they think it is, because they walk into that mediation think that they're dead right and that they're going to win. And the mediator's job is to try and get them to come together at some lower number. 25% of the time that happens. Okay. This is the area that Paul was talking about. Some exceptions to the mediation requirement are listed below. And well, it's further on. But arbitration of disputes is also it's like liquidated damages. It's a separate, you must initial it. Both parties must agree in order to have this paragraph in effect, and it is optional. And it goes on to say, if not settled through mediation, parties agree to be decided by neutral binding arbitration. Parties agree to arbitrate any disputes with brokers, but again, we're not required to arbitrate. I've got one going right now where they want to arbitrate with us. It's faster, easier, less expensive. I've chosen to not agree to arbitration because I know it's going to cost them more money for them to come after us. And so there's a strategy that we put into place that will require them. We won't agree to arbitrate with them, especially because they're arbitrating with the other party. So the broker is not bound to that. We're not required to arbitrate. Most of the time we will, but in certain instances we won't, depending on the topic. Qualifications are specified in the document on who the arbitrator can be. Usually it's a retired judge or attorney, and they must have some real estate experience because they're deciding on a real estate matter. So there are requirements that are built into the contract identifying what that person must be. By agreeing to arbitrate, the parties are giving up. It tells them they're giving up certain rights. They're giving up a jury trial, they're giving up the right to discovery, and they're giving up the right to appeal. So once the arbitration comes down, there's very limited ability to appeal, where if you lose a lawsuit, you can just, you can appeal to the Supreme Court. I mean, you go through the process. But when you're in arbitration, the whole intent of arbitration is to bring it together, less expensive, faster, easier, but there is a sacrifice in doing that. We're often asked, do we recommend that people sign the arbitration clause? And again, that's legal advice. We cannot give them legal advice. We can tell them what people normally do, and we can tell them that the intent of arbitration is to make it easier and faster. And you've all seen how impacted the court system is. Typically, arbitration is going to go much faster than a jury trial. Okay, the exclusions that Paula was talking about is foreclosure, unlawful detainer, probate, small claims, bankruptcy court, court actions that might preserve the statute of limitation. We talked about lis pendens. We talked about how they could, a guy that had a deposit that was in play, they could file lis pendens. So that doesn't nullify their right or their ability to then future mediate. But those types of actions are excluded from that requirement under the mediation clause. I think that's it for page 8. We're on page 9. How are we doing on time? Okay, we're at 43 minutes. I think we're going to try and blast through this. Selection of service providers, brokers, it just states clearly in the agreement that the brokers don't guarantee performance of any vendors. Buyers and sellers are free to choose whoever vendor they like. How many times do we hear from them? Well, you chose this person. Well, at the end of the day, they're free to choose whoever they like. And it says that in the contract. The MLS system authorization is given to brokers to report pending sales. We're giving permission. We're being given permission in the contract to provide the information to the MLS. Pending sales, sales price at closing, and then any other data that will be provided to the MLS for authorized use. So we can't just do that without the permission of the parties. There's an attorney's fees a clause in the document. Prevailing party in any action is entitled to reasonable attorney fees, except if mediation is not completed. That's where that's stated. Assignment. The seller's consent is required for any assignment. So if someone wants to transfer or they want to give some other portion of the transaction to another person, let's say they want to add a spouse. Okay, well, the seller's consent to add that person is a requirement. But it also goes on to say that the seller shall not unreasonably withhold that consent. But it also, and then it further says that the buyer is not relieved of any responsibility, the original buyer. So let's say they assume it, and there are some provision in the contract that the buyer must perform. If they assign the document, sign the contract, that doesn't relieve them of the responsibility to act. There's an ECOA. disclosure in there that basically is saying that the property is sold in compliance with the equal housing laws. Terms and condition of the offer, liquidated damages, and arbitration require mutual consent. So that's where it goes on to confirm. So everybody knows that those are items that need to be agreed to. A counter is needed until you have mutual consent. Seller can offer and accept. This is an interesting one. Seller can offer and accept any offer prior to notification of acceptance. Parties acknowledge that they have read the agreement and understand and agree to the agency relationship. If the buyer defaults, they may be responsible to pay the brokerage. Documents may be signed in counterpart, which constitute one and the same writing. So the interesting thing in the contract where it specifically says that the seller can offer and accept any offer prior to notification of the acceptance. Now, notification of the acceptance, okay, and delivery, so that has to be delivered back to the agent. So the timing becomes a little tricky on whether or not multiple offers. I don't know how I quite want to say this. It's until it's conveyed to the agent. I've always been of the thought that if the moment that a buyer signs the counteroffer, the deal is done. And so if you issue a counteroffer and it hasn't expired, but they haven't responded, if you have that counter out there, unless you revoke it, okay, unless you revoke it, you could end up in a double acceptance situation where what this paragraph says, and I haven't clarified it with CAR yet, which I'm going to. What this says to me is that you can accept another offer prior to that being delivered to you. And I don't think we ever want to get in that situation, but it seems to be that there's an opportunity there for someone to sell a property even though you have the counter out. But I'm going to confirm that and I'll come back to you with that. The other interesting thing is that if the buyer defaults, they may be responsible to pay the brokerage. It says that right in the contract. I've never seen that happen. I've never seen a broker do that, but it does say it. Time is of the essence. All understandings of the parties are contained in this agreement. How many times do you say, well, we've got this verbal situation. This was said or that was said. This says right in the contract that this is a complete contract. This is what we agreed to, okay? And the agreement can't be amended or modified except by written mutual agreement. So unless there's some additional writing that is mutually agreed by the parties, what the contract says is what it says. When we go into definitions, acceptance, the time the offer or the counteroffer accepted in writing by a party and is delivered to and personally received by the other party or the other party's authorized agent. So acceptance is not when they signed it, okay? Acceptance is when it was delivered and received by the other party. So by the agent, by whoever the agent is that's receiving that document back. If it's a buyer's agent, if it's just the contract, or if there's a counteroffer, then it's going to be the listing agent. Receiving that document back is the date of acceptance or the time of acceptance. Agreement. So the agreement is the document, the counters, and any incorporated addenda which collectively form the binding agreement between the parties. This last sentence came into play this week. Addenda are not incorporated only when signed by all parties. Addenda are incorporated only when signed by all parties. We had an addendum that was signed by a seller that was not signed by a buyer, which gave the buyer an option to do something, and it was never signed. And we're in a potential lawsuit. It's not a lawsuit yet, but it is a dispute between the parties. And the argument that the other attorney is going to use is that that addenda was never signed at the time of the agreement. So therefore, it is not part of our agreement. CAR form, the most current version of the form reference, close of escrow, COE, the date the grant deed or evidence of title as recorded, copy by any means, photocopy, NCR, fax, electronic. Days are calendar days. However, if the last day for the performance of any act required by this agreement including close of escrow, shall not include any Saturday, Sunday, or legal holiday, and shall instead be the next day. So we keep hearing people talk about business days. Well, there is no such thing as business days. It's calendar days. And all days count, no matter what they are, unless it's the day of the final act. So if it's removal of contingency, if it's contract, if it's close of escrow, whatever it is that's supposed to happen, if that falls on a Saturday, Sunday, or holiday, it reverts to the next day. Okay. But if you issue a notice to perform on Friday, okay, and Saturday and Sunday count in the 2 days because it's Monday that the actual act must occur. So it counts in the days, but if it falls on that date, then it reverts to the next day. Days after is defined as calendar days after not counting the first day and expiring at 11:59 the final day. Days prior is the specified number of calendar days to the event, not counting the day that the event happens on. So when you're talking about days prior, you're counting every day except for the date that it's supposed to happen. Delivery means personal receipt by the party or agent, regardless of how it's delivered. Okay, the fact that it was sent to their email doesn't necessarily mean that it was delivered, okay, because they haven't received it. Okay, they haven't actually seen it. If you can document, like for example, I use close, I have the ability to document when someone opens an email. So I can document, if necessary, that they actually did receive it. Delivery, let's see, electronic copy or signature, complying with the law, and that no party will modify the document without consent of the other party. So they can't just change the document through that process. Law is defined as code, statute, ordinance, regulation, rule of order by controlling city, county, state, federal, judicial, or executive. Repairs means any repairs, alterations, or replacements, modifications, or retrofitting of the property as defined under the agreement. Signed means electronic or ink. It can be copy or counterpart. You can have a husband and wife sign 2 separate documents and they're married into one agreement. That gives us, that is legal in the state of California. Paragraph 31 goes on to the expiration of the offer. The offer is deemed revoked and the deposit to be returned to the buyer if not signed and received by the time specified. And 3 days is the default that is offered. And we've got the signature block. There's a checkbox to notate if there's a representative capacity being used. There's a checkbox also for additional signature addendum if it's needed. And then page 10, paragraph 32 is the acceptance of the offer. The seller is warranting in this paragraph that they own the property or they have the authority to execute the agreement. The seller also agrees to the terms and he states that he's read the contract, received and understands the contract, and the agent is authorized to deliver it back to the buyer. So all those things are happening in that paragraph. There's a checkbox available if it's going to be attached to a subject to an attached counter. There's a checkbox available for representative capacity for the seller. There's a checkbox available for signature addendum if needed. And then initials for confirmation of acceptance is used if there's no other counter. The delivery creates binding agreement whether acknowledged or not. So you don't necessarily have to have acknowledgement in that on the form. It's best to do that. It's professional to do that. But the moment it's delivered and received, then that's when the binding agreement has been created. We go on to the real estate brokers box. It states that the brokers are not, they're reminding the principals again, that the brokers are not parties to the agreement with the buyers and seller. The agency relationships are confirmed on page 1. The buyer broker acknowledges receipt of the deposit if applicable. And then cooperating broker compensation, the listing broker agrees to pay and the buyer's broker agrees to accept the amount posted on the MLS, provided they are members of the buyer's agent is a member of the MLS. If not, the compensation must be specified by some other agreement. There's a box for presentation of offers. If the buyer agent requests that the seller's agent, they must confirm in writing that the offer was presented. Let's see here. Real estate, additional to the broker's box, signature lines and contact information for both the listing agent and the buyer's agent is there. Then there's a box for escrow. So escrow acknowledges receipt of the offer, the deposit, and the amount if applicable. If they've received any counters, those need to be numbered there. The statement of information and any other items that are being given to them, they would notate in that box. They acknowledge in this box that they agree to act as the closing agent. So they're basically agreeing that they're going to perform those functions. They confirm the date the deal was accepted, state their name, assign the number, and provide contact information. They also specified as the type of escrow company they are. They're either a DBO, which is an independent escrow company like Alpine or Escrow Avenue. They're a DOI escrow company, which is a Department of Insurance, which is going to be any of the title companies typically, or they're going to be a DRE escrow company, which is going to be a non-independent company. As a broker, I could open a DRE escrow company, but it's not going to be an independent company. And then presentation of the offer is initialed by the agent and acknowledges when it is presented. So it's the opportunity for the agent to be able to document when they presented it and that they actually presented it. And then if the offer is just outwardly being rejected, then to bring closure to the transaction, again, is not required, but to bring closure to the transaction, there's an opportunity in a space for the seller to initial and date that they rejected the offer. And that is it that we're going to go through for today. So
Steve, I have one quick question, if I can.
Sure.
Going back to the last page at the very bottom then, so are we supposed to sign that we've actually presented that offer? Because I've never done that. Is that something new we're supposed to do?
Like the rejection, it's not a requirement.
Uh-huh.
Let me stop sharing my screen. It's not a requirement, but it brings closure. So, you know, I mean, if they ask for it, it's not required, Pat. It's not something that absolutely has to happen, but it's just an opportunity for you to document when you presented it and that you actually presented it. So the answer to your question is it's not a requirement, but I'd recommend that you do it.
It's a good idea. Okay, thank you.
Yep. Any other questions, comments? Okay, so we had.
I would wait. How do I talk? I have a comment. Just I remember Robert Brown doing the risk management for us in a MLS meeting, and he made it really clear to us that delivery of the contract and of the TDS, et cetera, if we deliver those to a TC, that is not delivery. That it has to go to the party or the agent in order for it to be good delivery.
That is correct. Yeah, it has to be the authorized agent. If the TC is on the transaction, in other words, they're a licensee and they are part of the transaction, then that does suffice. But in most instances, that's not the case, and so it does. You do need to document that it actually goes to the agent as delivery. Any other questions? Was this helpful to you? Okay, I'm going to next week. We are going to do some of the ancillary documents that go along with the purchase agreement. So we're going to try and blast through those. I'm going to try and do those quicker. We don't need to spend as much detailed time on them, but just so you understand what those documents are. For example, contingency of sale property, the COP document. We'll go through documents like that. So no other questions. Have a good one, and thanks for tuning in. And this will be posted so you can refer back to it on YouTube. Thanks, you guys.
Thank you, Steve.